Hello, everyone. Welcome to our pre-review session for Law on Sales. So what is the nature and form of the contract of sale? So under Article 1458, by the contract of sale, one of the contracting parties obligates himself to transfer the ownership and to deliver a determinate thing, and the other to pay therefore a price certain in money or its equivalent. A contract of sale may be absolute or conditional. So, what are the elements of a contract of sale? So, we have three kinds of elements. Number one is the essential elements. The second one is natural elements. And the third one is accidental elements. When you say essential elements, it means that these elements should be present in order for a contract of sale to exist. So kung kulang yung essential elements, kaya nga tinatawag natin siyang essential kasi required siya na meron dapat siya in a certain contract para mag-exist yung contract of sale at para maging valid yung contract of sale. So the essential elements are, number one, consent. Now, this is very important because based sa definition natin kanina na a contract of sale is a contract. Remember that contracts are perfected by mere consent. No, kailangan talaga ng consent in a contract para ma-perfect siya, including contract of sale. So, first natin na element na pinaka-importante is yung consent ng contracting parties. Second one, determinate object. So, just like any other contracts, kailangan meron tayong object, no, in a contract of sale. Like, for example, yung sale of land. So, yung object doon is yung land. Diba? So, third, price certain in money or generally, ang tawag natin dito is consideration. Take note here that the price must be certain. Hindi pwedeng, like, for example, ako, I will sell to you a land. Depende sa iyo yung price. So, meaning to say, hindi ka sigurado magkano yung price ng land na yan. So, therefore, hindi siya certain. So, dapat, in order to comply with the requirements of the law na para ma-complete natin yung essential elements, kailangan yung price should be certain. Now, another kind of elements is natural elements. Natural elements ang tawag sa kanila kasi you need not agree expressly about these elements because sabi ng batas, these natural elements are deemed written into any contract of sale or deemed or impliedly included na siya sa kontrata kahit na hindi na pag-usapan ng parties. One is warranty against eviction and the other one is warranty against hidden defects and encumbrances. So we will discuss these two natural elements later. No? Third one is accidental elements. When you say accidental elements, this refer to the stipulations of the contracting parties. Kung yung natural elements ay they are impliedly included no, in a contract of sale kahit na hindi pinag-usapan ng parties, itong accidental elements, ito yung mga stipulations or mga agreements between the contracting parties that are expressly provided by them. So, kung hindi nila ito pinag-usapan, therefore, hindi sila deemed included no, in the contract of sale. Characteristics of a contract of sale. So we have 1, 2, 3, 4, 5, 6 characteristics. Number one is consensual. Consensual means yung contract of sale daw can be perfected by mere consent. Meaning to say, kapag once nag-agree na kayo, nag-meet na ang minds ninyo regarding the price, regarding the object, then perfected na yung sale. So this means that hindi kailangan ng written agreement in a contract of sale. Pwedeng oral lang, basta nagkasinabot na mo sa imong kakontrata. Principal, meaning to say, itong contract of sale, hindi siya nagdedepende sa existence of another contract. Meaning, it can stand alone. Ano yung opposite ng principal? Accessory. Yung mga accessory contracts, they cannot exist without a principal contract. Like for example, yung mga mortgage contract, di ba? Yung mga real estate mortgage, kailangan merong promissory note, merong principal obligation before ka mag-enter into real estate mortgage. Kasi ang isang real estate mortgage is an accessory contract. But a contract of sale can stand alone without any contract, no? Without another contract. So therefore, it is a principal contract. Bilateral because there are two parties involved here. And the parties here, the buyer and the seller, have the reciprocal obligation between each other. On the part of the seller has the obligation to transfer the ownership of the thing, to deliver the thing. On the other hand, the buyer has the obligation to pay the price, therefore, and to accept the thing, no, when it is delivered. Onerous, which means that a contract of sale has a valuable consideration. Hindi siya for free. Yan ang ibig sabihin niyan. Commutative, meaning the consideration exchange are of equivalent values. Like, if you want to buy a land, yung binabayaran ng buyer is yung value ng land, yung equivalent value ng land. Kaya commutative siya. Nominate, because a contract of sale has a name given by law, which is sale. No? Stages of a contract of sale. Preparation or conception. The time the contracting party shows interest in the contract. Like negotiation stage, no? Yung mag-offer ka, kung magkano yung gusto mong price, then mag-offer ka to buy. So dito yun nangyayari yung mga negotiations. Perfection or birth, meaning kapag yung lahat ng elements ng contract of sale, yung consent, object, and price, na-concur na yun sila lahat, then a contract of sale has been perfected or meron ng birth of a contract of sale. Consummation or death means that na-extinguish na yung contract of sale. Like, by the modes of extinguishing obligations. Now, if you can still remember, ano ba yung mga modes of extinguishing obligation? Di ba we have, first one is payment or performance, di ba? So, kung in a contract of sale of land, kung nabayaran na ni buyer yung amount, tsaka na-deliver na din ni seller, then consummated na yung contract of sale. And therefore, since consummated na siya, na-extinguish na yung obligation. So what is the nature of the obligation created by a contract of sale? On the part of the seller, yung obligation niya kapag nag-enter siya into a contract of sale is to transfer ownership and to deliver possession of the subject matter. Kasi, bakit ka magbebenta ng bagay na hindi mo naman mai-deliver, di ba? So you have the obligation to transfer the ownership. So like for example, kapag sale ng lupa, kailangan mong i-deliver yung possession at saka ownership. Paano? E di mag-execute ka ng deed of absolute sale at i-deliver mo yung titulo or any proof of ownership, di ba? So you should deliver everything, no, na necessary para ma-transfer yung ownership. For the buyer naman, of course, to pay the price, no? Alangan naman bumili ka na wala ka namang pera. So dapat bayaran mo yung price. So ito yung mga obligation created by a contract of sale. Now, sale as a title. So contract of sale doesn't transfer the ownership of the subject matter. It is merely a title that creates the obligation to transfer ownership and a mode thereof. The contract of sale transfers no real rights. Ownership and possession is transferred through delivery or tradition. So kapag meron na kayong contract of sale, meron ka na kayong title, you now have the right to demand on the part of the buyer to demand the delivery of the thing or of the object, subject of the contract of sale, and to demand the transfer of ownership. On the part of the seller, meron na siya ngayong title to demand the payment of the price of the object, no, in the contract of sale. So meaning to say, kapag pala merong contract of sale, hindi siya automatically natatransfer yung ownership. Kasi nakalagay sa batas na para matransfer yung ownership, dapat i-deliver yung property. Malaman natin yan later. No? Now, let us distinguish sale from other contracts. Donation. So, ano ba yung kaibahan ng sale at donation? Yung sale, oniro siya, meaning to say, merong bayad. Yung donation, gratuitous siya kasi free, di ba? Kaya nga, donation yung tawag sa kanya. Yung sale naman, perfected by mere consent, meaning to say, pag meron lang consent, merong object, tsaka merong price certain, meron ng perfected contract of sale. Meeting of the minds lang ang kailangan. But in donation, it is perfected by donee's acceptance. Kasi meron tayong requirement sa batas na kailangan yung donee i-accept niya yung thing donated. Kasi sabi pa nga nila, you cannot compel the person to accept one's liberality, di ba? You cannot compel one to accept the liberality of another. So parang ano siya, no? Parang choosy siya, pero yan talaga yung nakalagay sa batas, no? Hindi mo pwedeng ipilit na tanggapin niya. Kaya hindi siya mapa-perfect. Kahit na i-deliver mo pa yung thing donated, hindi siya mapa-perfect, not unless si donee accept niya yung donation. Donation is an act of liberality whereby a person disposes gratuitously of a thing or right in favor of another who accepts it. Ayan, nakalagay talaga expressly sa definition ng donation na dapat yung person na pinag-donitan, i-accept niya yung thing donated. Now, with barter, in sale, the cost or consideration is money, pera. But in barter, the cost or consideration is another thing. Kaya nga barter, di ba? Meaning exchange of another thing. Ganun lang. By contract of barter exchange, one of the parties binds himself to give one thing in consideration of the other's promise to give another thing. Now, what if the consideration is partly in money and partly in another thing? So the type of contract is determined under the following hierarchy. First, rule natin dyan is, ano yung intention ng parties? Kung partly money and partly in another thing, like for example, 5,000 cash and a cell phone. So, paano ba natin malalaman kung ito ay sale or barter? Sabi ng batas, yung rule talaga kung ano yung intention ng parties. Kung gusto ng parties na sale yan, di sale yan. Kung gusto naman ng parties na barter yan, edi barter. Kasi masusunod kung ano yung intention ng parties. Pero, if the intention is not clear, the following rules shall apply. Number one, thing is more valuable than money. Kung mas mahal yung thing, then barter ang tawag sa kanya. But if the money is equal or more than the value of the thing, then it is considered as sale under the law. Now, contract for piece of work. Now, in sale, it is ordered in the ordinary course of business. Like for example, yung sapatos ba sa mall? Di ba yung sapatos sa mall, naka-display yan lahat. So, ikaw na lang yung client na mamimili kung ano yung shoes na bibilin mo. So, ito yung mga goods or mga products that are sold in the ordinary course of business. While on the other hand, yung contract for piece of work made specially for the customer upon his special order. Like, kasi you have, for example, yung paa mo is, hindi siya, yung size ng paa mo, hindi siya available sa malls. So therefore, gusto mong magpagawa ng special order na talagang fit, no? Fit on you, on your feet, diba? So meaning to say, specially ordered siya. Yan yung contract for piece of work. Hindi mo siya mahahanap kahit saan, no? Or meron ding mga contract for piece of work na like you want a unique dress. So pumunta ka ngayon sa sastre, nagpagawa ka ng dress. So that is contract for piece of work, no? Yung design niya is according sa gusto mo. Or tinatawag nating customized, di ba? In sale, thing transferred already existed and can be a subject of sale to other person. So sa sale, di ba, gaya ng sabi natin kanina, sa mall, punta ka doon, then may mga sapatos na ka-display doon, available na siya for sale, no? At the time na gusto mong bumili. But with the contract for piece of work, hindi pa siya available. Ipapagawa mo pa lang siya. Okay? sale within the statutes of fraud, while contract for piece of work not within the statutes of fraud. Malalaman natin mamaya ano yung statutes of fraud. When each product or system executed is always unique and could not mass produce the product because of its very nature, such is a contract for a piece of work. Now, what about dasyon and pago? So in sale, there is no pre-existing debt. Pwede ka naman bumili, di ba, kahit na wala kang utang sa seller. Dasyon and pago with pre-existing debt. Kasi yung dasyon and pago, isa itong mode of extinguishing an obligation. Di ba? Kasi generally, yung isa sa mga mode natin is payment or performance, di ba, of the obligation. Bayaran mo yung obligation with cash. Pero may mga ibang instances na instead of cash yung ibayad natin, bagay na lang. Properties na lang, di ba? So, dasyon and pago is a mode of payment, no? Mode of extinguishing obligation. So dito, sa dasyon and pago, dapat merong pre-existing debt. May utang, no? In sale creates an obligation, no? Kapag once nag-enter kayo into contract of sale, magkakaroon ng obligation yung seller tsaka buyer. But in dasyon and pago, di ba sabi natin kanina, it is a mode of payment. So therefore, since it is a mode of payment and payment is one of the modes of extinguishing obligation, then it extinguishes an obligation. Freedom in determining the price, no? In sale kasi you have the freedom, di ba, as a seller. Tsaka yung buyer naman, pwede siyang mag-counter offer. So depende sa gikasabutan. But in the dasyon and pago, the price is the value of the thing given. Like for example, yung utang mo 1 million. Yung ibabayad mo is worth 2 million. So in dasyon and pago, you cannot ask for change, no? Gaya ng normal ba na pag magbayad ka ng utang, di ba? Like 1 million, tapos binayaran mo siya ng 1.5 million, so babalik niya sa'yo yung 500,000, di ba? But here, in dasyon and pago, hindi. Kasi yung property na binabayad mo ngayon para dun sa utang will be considered as the equivalent of the loan or the utang. So, last, the cost or consideration is the price and delivery of the object. Diba? On the part of the seller, yung price. On the part of the buyer, yung delivery ng object. Dasyon and pago, yung cost ng or consideration natin dyan is yung extinguishment ng obligation and the delivery of the object. Contract to sell. Sale, ownership is transferred upon delivery, while in a contract to sell, ownership is transferred upon full payment of the price. Meaning to say, yung contract to sell, meron siyang suspensive condition. Na kailangan, bayaran mo muna yung in full before siya ma-vest yung ownership sa'yo. Diba? Yan yung contract to sell. Sale, non-payment is a resolutory condition. Ano nga ulit yung resolutory condition? Diba, sa obligations and contracts, nakasabi doon na if the condition arrives or if the condition happens, the obligation is extinguished. Yan yung resolutory condition. So meaning to say, in sale, kapag hindi ka nakabayad ng utang, ng product, hindi mo nabayaran yung product, then that can be a ground, no, for the extinguishment of the obligation. So you can file for rescission of contract. But here, in contract to sell, full payment is a positive suspensive condition. So, sinabi natin kanina na sa contract to sell, meron siyang suspensive condition, yung full payment of the price. So, di ba sa contract to sell, parang a preparatory contract siya. Hindi siya, kahit na nag-execute na kayo ng contract to sell, hindi siya equivalent to a contract of sale. Kasi sa contract of sale, kahit na hindi mo pa nabayaran yung full payment, for as long as na-deliver na yung property, matatransfer na yung ownership. But here in contract to sell, kahit na i-deliver yung property, kapag hindi talaga na fully paid yung amount, hindi ka talaga magiging owner ng property kasi the full payment of the price is a positive suspensive condition. So kapag na-full mo yung price, saka pa kayo mag-execute ng contract of sale. In sale, it is already perfected, no? Meaning, meron talagang obligation na mag-arise. But here, in contract to sell, no perfected sale yet. Kasi, hintayin mo na ma-full yung payment ng price. Subsequent buyer is presumed to be in bad faith in sale. In contract to sell, subsequent buyer is presumed to be in good faith kasi wala pa namang sale, di ba? Kasi sa sale, kapag nabenta mo na sa isa, tapos may subsequent buyer na naman, like double sale siya, yung second na buyer will now become, will be presumed in bad faith. Kasi nabenta na sa iba, bakit ikaw bumili ka pa rin, di ba? So last is vendor loses and cannot recover ownership of the thing sold until contract of sale is resolved and set aside. So once nagbenta ka, nag-enter ka into contract of sale, then hindi mo na ma-recover yung ownership, no? Kahit na hindi pa na fully paid yung price. Ang gawin mo is to collect, no, the price or to rescind the contract para mabawi mo yung ownership. But in contract to sell, yung title, yung ownership, nagre-remain sa vendor, no? If the vendee does not comply with the conditions of the contract. Agency to sell. So buyer receives goods as owner in a sale, but in agency to sell, agent receives goods of the principal who retains ownership. Kasi agent ka lang, parang gusto mo lang ka ba, no? Buyer pays the price, but agency to sell, agent delivers the price which he got from his buyer. Sale buyer as a general rule cannot return the object sold, but in agency to sell, agent can return the goods. Seller warrants the thing sold, the agent makes no warranty kasi hindi siya ang may-ari. Ang nagwa-warranty niyan is yung may-ari. Buyer can deal with the thing sold, agent can deal with the thing received as long as it is within his authority given by the principal. So, we have two kinds of contract of sale. We have absolute and conditional. Yung absolute, meaning wala siyang condition. Once nag-enter ka into contract of sale, the title immediately passes to the purchaser upon delivery. But when you say conditional, ownership of the object remains with the vendor until fulfillment of the condition. Like for example, yung condition is kailangan ma-full yung payment ng price, no? So meaning to say, kapag hindi mo pa na fully paid yung price, yung ownership magre-retain kay vendor. Iba din itong conditional sale sa contract to sell, no? Kasi sa contract to sell, walang perfected contract of sale, no? Yung payment ng price will become a positive suspensive condition that will give rise to a contract of sale. But here, in conditional contract of sale, the sale is already perfected. Upon fulfillment of the condition, ownership automatically transfers to the buyer. But in a contract of sale, contract to sell, yung ownership hindi automatic na transfer. Kailangan nyo munang mag-enter into contract of sale bago at mag-deliver bago ma-transfer yung ownership. But here in conditional, once ma-fulfill yung condition, automatic yung transfer. Last distinction, lease. In sale, ownership transferred by delivery, seller must be the owner at the time of delivery. So meaning to, ang ibig sabihin niyan, kunyari at the time of sale, hindi pa si seller yung owner, okay lang daw. Basta at the time of delivery of the thing, siya na yung owner. But in lease, walang transfer ng ownership kasi renta lang yung lease. And lessor need not be the owner. Okay, kasi pwede merong mga sublease eh. Yung lessee, nilease niya rin sa iba. One person binds himself to grant temporarily the use of the thing or to render some service to another who undertakes to pay some rent. So that is lease. Now let's go to object or subject matter. So what are the requisites? Ito yung second na element, di ba? Kasi yung una is consent. The requisites of a valid subject matter. Kung bagay yan siya, dapat it must be licit or lawful. It should not be impossible. determinate or capable of being determined or determinable. And if it is for rights, it must be transmissible and licit. Goods which may be object of sale, existing goods, goods owned or possessed by the seller, and future goods, goods to be manufactured, raised, or acquired by the seller after the perfection of the contract. So, pwede pala yung mga future goods magiging object ng contract for as long as they will come into existence. Hindi pwede yung magbibenta ka ng something na hindi naman mag-i-exist in the future. So, pwedeng future goods basta sure ka talaga na it will come into existence. These are things which are expected objects. Ayan, this refers to future goods pala. So, objects must be within the commerce of men. If the subject is illicit, contract is void and cannot be ratified. Kasi isa sa mga requisites, dapat lawful yung thing. Like for example, sale of drugs. Sinasabi ng batas, bawal magbenta ng drugs. So, ibig sabihin, invalid or hindi lawful yung object. Dahil hindi lawful yung object, isa sa mga requisites of a valid subject matter is not present. Therefore, there is no valid object or subject matter. Kapag walang valid subject matter, meaning hindi kumpleto yung elements ng contract of sale. So, ang effect niyan, walang contract of sale. Instances of sale of things not actually or already owned by the seller at the time of sale, like sale of thing having potential existence, sale of future goods, contract for the delivery at a certain price of a thing the vendor produces in the ordinary course of the business or for the general market. For example, ito yung mga crops. Basta meron ka talagang like rice, di ba? Dapat, pwede mo ibenta yan, no? Future goods yan kasi hindi pa siya na-harvest, no? So, that can be a valid object of a contract of sale. So, let's talk about the element licit. Kailan ba nagiging valid or naging lawful yung object? Number one, if it is within the commerce of man, meaning it can be the subject of a commercial transaction. Second, when right is transmissible, meaning pwede siyang matransmit from one person to another. Third, it does not contemplate a future inheritance unless expressly authorized by law. So, dapat hindi siya future inheritance. Yung parang pinatay mo na yung parents mo, ikaw na anak, buhay pa yung parents mo, binenta mo na yung lupa na pagmamayari ng parents mo. So, that is a future inheritance. Therefore, hindi siya pwede maging object or subject matter ng contract of sale. Ano yung mga example ng properties na not within the commerce of man? Of course, yung mga public property. So, hindi mo pwedeng ibenta yung capital sa ibang tao, no? Kasi hindi mo naman yan pagmamayari, di ba? You cannot give what you do not have. So, ano yung mga examples ng public property? Yung mga hospital, yung roads, bridges, di ba? Yung river, hindi mo pwedeng ibenta yan kasi that is part of the public dominion. The church, no, hindi pwede. Narcotics or drugs kasi by provision of law, no, prohibiting the sale of narcotics or drugs. Ano yung mga kinds of illicit things per se, meaning by its nature, no? For accidents due to provisions of law declaring it illegal. Example nito is yung mga drugs or narcotics. Existing future contingent. Goods which form the subject may either be existing, goods to be manufactured, raised, or acquired by the seller, things having potential existence, sale of specific things, fungible goods, undivided interest. Ano itong undivided interest? Like, co-owner ka, marami kayo owner sa isang property, undivided interest yan siya kasi hindi pa talaga nasukat kung ano talaga yung meets and bounds ng ownership mo. Kaya undivided interest. So, a co-owner actually can sell his share in the undivided property. Now, M2 parity versus M2 pay. Ano ba itong M2 parity? Ito yung future goods, no? It is in the form of a present sale. And it is valid only as an executor contract to be fulfilled by the acquisition and delivery of the goods specified. While emptuous pay, it is the sale of a mere hope or expectancy. The sale in itself is so let's distinguish now emptuous res parate and emptuous pay. In emptuous res parate, sale of an expected thing. Kasi pwede namang maging object yung mga future things. Emptuous pay, sale of the hope itself. Okay? Subjected to the condition that the thing will come into existence. In emptuous pay, sale produces effect even if the thing does not come into existence. Uncertain with regard to quantity and quality of the thing. In emptuous pay, uncertain with the existence of the thing. Emptuous res parate, object is a future thing. Emptuous pay, object is a present thing. Now, sale of specific things. Sale of things in litigation entered into by defendant without knowledge and approval of the litigants or the court is rescissible. So rescission will not take place when the thing legally is in the possession of a third person who acted in good faith. Sale of undivided interest makes the buyer a co-owner of the thing. Like for example, no, si A at si B, owner sila ng isang lupa. Si A, binenta niya yung kanyang share kay C. So ngayon, si C magiging co-owner na siya kasi na-acquire niya yung share ni A. The co-owner can dispose his share even without the consent of the other co-owners. Sale of undivided share of a specific mass of fungible goods, gaya ng rice, di ba? Kasi fungible yan, hindi mo ma-count, no? The sale of an undivided share makes the buyer a co-owner of the entire mass in proportion to the amount he bought. Sale of things subject to a resolutory condition. If the resolutory condition happens, the vendor cannot transfer ownership of what he sold since there is no object. Kasi yung resolutory, extinguished, di ba? Kapag nangyari. So, hindi na niya pwedeng matransfer yung ownership. So, the object, aside from being licit, it must be determinate or determinable. Determinate. A thing is determinate when it is particularly designated or physically segregated from all others of the same class. So, ang ibig sabihin lang yan, kung kaya mo siya i-segregate, i-identify na siya lang one and only thing, which is the subject matter of the contract, then that is determinate, no? Like for example, I will sell to you this bag. So, because of the words this bag, even if hindi natin dinescribe kung ano talaga yung bag, that bag now is a determinate thing. Kasi wala namang ibang this bag, no? Itong bag na to. Sabi ko itong bag na to. So, meaning, ma-designate natin siya, physically segregate natin siya from all others of the same class. Determinable, a thing is determinable, it is capable of being made determinate at the time the contract was entered without the necessity of a new or further agreement between the parties. Price. It is the sum stipulated as equivalent to the thing sold and also every incident taken into consideration for the fixing of the price put to the debit of the buyer and agreed to by him. So what are the requisites? Certain, and a certain at the time of perfection. So kung at the time of sale, wala mo sure kung how much talaga yung price, then hindi siya certain, no? Kasi dapat at the time of perfection, the price must already have been certain. It must be in money or its equivalent or real and not fictitious. Hindi gawa-gawa lang. Like for example, yung iba, para mag-appear lang siya na sale, so nilagyan lang nila ng consideration, pero ang totoo, wala talagang consideration. Certainty of price. Price must be certain, otherwise the sale is void by reason of absence of meeting of minds. Inadequacy of price. Like for example, yung value ng lupa, 1 million, pero yung price mo, 800,000. Will that affect the validity of the contract of sale? Generally, gross inadequacy of price does not affect the contract of sale. Except that it may indicate a defect in consent, no? So, with respect to voluntary sales, yung mere inadequacy of the price does not affect the validity of the sale kasi voluntary yung sale, pinag-usapan. Except na lang kung when low price indicates vice of consent. Meaning, hindi talaga alam ni seller kung magkano talaga yung, wala talaga siyang idea, tapos, ano siya, or pinilit lang siya for that price, no? Or if merong fraud, no? Where the price is so low as to be shocking to the conscience. Like, 1 million yung value ng property, piso yung naging consideration. So, shocking siya to the moral conscience. So, yung sale, pwede siyang iset aside. Where the parties did not intend to be bound at all. Meaning, nag-enter lang sila into contract pero talagang walang contract. So, void yung contract kapag ganyan. What about involuntary sale? Yung mere inadequacy of the price is not a sufficient ground for the cancellation. Except na lang where the price is so low, no, yung more shocking to the moral conscience. In the event of resale, a better price can be obtained. Ito, simulation of price. Relative simulation, price stated in the contract is not the true price parties intended to be bound. So dito, meron talagang contract of sale. Kaya lang, binago lang nila yung price. Hindi talaga yung totoong price. Yun yung relative simulation. Yung absolute simulation naman, na the parties executed a contract of sale pero talagang walang contract of sale. Hindi talaga siya nag-exist, no? Hindi talaga totoo. Atik-atik lang. So, if that is the case, the parties never intended to be bound at all. The contract is void and inexistent. Failure to determine price. Where contract executory, contract is without effect. Kasi hindi pa na-execute yung contract. There is no obligation created. Where delivery has been made, the buyer must pay a reasonable price. So what is reasonable price is a question of fact dependent on the circumstances of each case. It may be determined on the basis of a company's balance sheet, showing the book or fair value of its shares. No? Earnest money. This is the partial payment of the purchase price and considered proof of the perfection of the contract. Like for example, yung value ng lupa 1 million, tapos nag-down ka ngayon ng 100,000. So that is earnest money. So kung yung binigay mo na pera will be deducted from the purchase price, earnest money yun siya kasi down payment. Okay? So let us distinguish earnest money and option money. So yung earnest money, part siya ng purchase price kasi down payment siya, while option money is separate and distinct from the purchase price. Yung option money lang kasi parang reservation. Nag-reserve ka lang. So kapag hindi mo tinuloy yung sale, mafo-forfeit yung reservation fee. Given only when there is already a sale, no? Pag earnest money. Pag option money naman, given when sale is not yet perfected. Earnest money, buyer is bound to pay the balance. Option money, would-be buyer is not required to buy. Parang yun na nga, di ba? Reservation lang siya. In case of non-payment, specific performance or rescission can be filed. But in option money, in case of non-payment, there can be an action for specific performance. Expenses for the execution and registration of sale shall be borne by the vendor unless there is a stipulation to the contrary. Remedies of a vendor to unpaid price. Paano kung yung vendor hindi siya binayaran? So, exact fulfillment, meaning i-demand mo na bayaran ka. Cancel the sale or rescission. Should vendee fail to pay 2 or more installments. Foreclose the chattel mortgage. So, what are the requisites? Must be a contract of sale. Object is personal property. Sale must be in installments. Does not apply for sale for cash or straight terms. O itong unpaid price. Okay? Offer.
So general rule, offer may be withdrawn at any time without even communicating such withdrawal to the interested buyer. So kunyari, nag-offer ka na magbenta. Anytime, pwede mong i-withdraw yan. Except na lang, when the offeror has allowed the offeree a certain period to accept, may be withdrawn at any time before acceptance by communicating such withdrawal. So generally, you are not required to communicate your withdrawal. Pero kapag like, binigyan mo si buyer ng time to decide, then dapat mo talagang i-communicate kay buyer na i-withdraw mo siya before acceptance. Exception to the exception, you cannot withdraw the offer within a certain period if found under a consideration. Meaning to say, like binigyan mo si buyer ng 10 days to decide. So, tapos si buyer ngayon, binayaran ka niya ng 10,000. May consideration yung period. So, hindi mo pwedeng i-withdraw. Option contract, it is an accepted unilateral promise to buy or sell supported by a consideration distinct from the price. It secures the privilege to buy. Yung ano kasi, yung sa option contract kasi, para hindi yan ibenta ng seller sa iba. Kaya yung iba, nag-enter sila into option contract. Kinds of promises, unilateral promise to sell, unilateral promise to buy, and bilateral promise, meaning yung both parties, meron silang promise to each other. Acceptance. The acceptance referred to which determines consent is the acceptance of the offer and not of the goods delivered. So requisites, dapat absolute yung acceptance mo, hindi ka na mag-counter offer. Like for example, si seller, nag-offer siya na ibenta niya yung lupa for 1 million. Tapos ngayon, ikaw sabi mo, okay, bibilin ko yan for 800,000. That is not an absolute acceptance kasi nagbigay ka ng counter offer. Hindi mo talaga in-accept yung entire offer ng seller. It must be plain and unconditional. Like for example, yung buyer sabi niya, palito na ko na kung apil itong isa, kung tapad na yuta. So that is conditional already. So hindi siya absolute acceptance. To bind the offeror, the offeree must comply with the conditions of the offer. Perfection. Contract of sale is perfected at the moment of the meeting of the minds of the parties. Kasi nga, contract of sale is a consensual in nature which is perfected by mere consent. So once perfected, the parties may reciprocally demand performance, no, from each other. Bound na sila, no? Kaya nga sabi ng obligations and contracts na contracts daw have the force of law, no? Is the law between the contracting parties, no? Kailangan the parties should comply with it in good faith. Requirements for perfection when parties are face to face, when an offer is accepted without conditions and without qualifications. If negotiation is made through a phone, it is as if the parties are face to face. Or on a face-to-face. When contract is through a correspondence or through telegram, there is perfection when the offerer receives or has knowledge of the acceptance. When sale is made subject to a suspensive condition, perfection is when from the moment the condition is fulfilled. Statute of frauds. So, na-mention natin kanina, di ba, yung statute of fraud. May mga transaction kasi na kailangan in writing. Though generally sabi natin kanina na contract of sale is consensual in nature, perfected by mere consent. Pero merong mga provisions sa batas na nagre-require na may mga certain sales of goods or properties that should be in writing. Otherwise, the contract of sale is unenforceable. So ano yung mga contract na kailangan in writing? Number 1, sale of property at price not less than 500 pesos. So, pwede yang in a private instrument lang. Hindi kailangan notaryado. Second, sale not to be performed within 1 year. So, kung hindi siya ipe-perform within 1 year, like, baligyan na ako ni Yuta sa imuha 2 years from now. So, dapat it should be in writing. Sale of real property or interest therein. Kasi, sabi ng batas, kailangan daw kapag lupa yung binibenta or building yung binibenta, kailangan talaga it should be in a public instrument. Meaning, kailangan notarize yan ng lawyer or notary public. take note that this statute of frauds is applicable only to executory contracts, meaning yung mga kontrata na hindi pa na-execute. Kasi once na-execute na yung contract, either totally or partially, then you cannot invoke now the statute of frauds. Sale by auction. Paano ba nape-perfect yan? So, by the fall of the hammer, gavel, or in any other customary manner. No? Sale of goods by description. Seller sells things as being a particular kind, and buyer has not seen the article sold and relies on the description given by the buyer. Sale by sample. Ay, basahin nyo lang yan. Parties contracted solely with reference to the sample. What is the effect of perfection? The parties must now comply with their mutual obligation. Otherwise, pwedeng magkaroon ng remedy yung aggrieved party, no? Pwede siyang magkaso, no? Sue for damages, no? Capacity to buy and sell. All persons who can bind themselves by contract have also legal capacity to buy and sell. No? So lahat ng tao na of legal age and have the legal capacity to enter into contract, pwedeng magbenta or magbili. So what are the kinds of incapacity? Absolute and relative. When you say absolute, persons cannot bind themselves at all, like minors, insane or demented persons, deaf mutes who do not know how to write, and those suffering from civil interdiction. Ano yung civil interdiction? Yung mga, ano kasi yan, penalty kasi yan sa criminal offense, no? Meaning, you cannot sell your property, you cannot manage your property. So yan yung civil interdiction. So if you cannot manage or sell your property, then you cannot enter into a contract of sale. Relative incapacity only with regards to certain persons and certain class of property. Like husband and wife cannot sell to each other. Kasi common yung property nila. Kahit na si wife yung bumili ng car, pagmamayari pa rin niya ng husband. Exception, when separation of property was agreed, like yung kanilang property regime is complete separation of property, kanya-kanya talaga sila. Or when there was a judicial separation of property. So let's talk about relative incapacity. So may mga persons na they cannot acquire property by purchase, no, even at a public auction, either in person or through damagiation of another. Example, guardian, yung property ng kanilang ward, hindi nila pwedeng bilhin. Agents, yung property under their administration or entrusted to them. So hindi pwede. Executors and administrators, property of estate under their administration. Public officers and employees with respect to the properties of the government. So hindi sila pwedeng maging buyer ng mga properties ng government. Judges, justice, prosecuting attorney, clerks of court, etc. with respect to the property in custodia legis, no? Or property in litigation, and other persons disqualified by law. Effect of violation from 1 to 3 from guardian, agents, executors, and administrators, magiging voidable yung contract of sale. But with respect to public officers, judges, other persons disqualified by law, null and void yung contract of sale. Meaning, it cannot be subjected to ratification. Kasi it is a violation of public policy. Loss and deterioration. Sorry, wrong spelling. Resperate domino. What is this concept? The concept that owner bears risk of loss and deterioration because ownership is not transferred until delivery. Or short for, ang short niyan is the thing perishes with its owner. Para yan yung resperate domino. So ano yung rule natin in case of loss and deterioration? Before perfection of the contract of sale, it is the seller that bears the risk. Why? Because at the time, the seller is still the owner of the thing. Kasi nga, ang basis natin is yung principle ng res perit domino. The thing perishes with its owner. At the time of perfection, the contract is void or inexistent. Bakit? Kasi one of the requisite of a valid contract of sale is the existence of a valid object. So kung nawala siya at the time of perfection, meaning to say walang object. Kung walang object, walang contract of sale. Kaya void or inexistent yung contract of sale. At the time of sale, if entirely lost, contract is void or inexistent. If partially lost, vendee may elect between withdrawing or demanding the remaining part. After perfection but before delivery, take note that delivery transfers ownership. So, kung after perfection but before delivery, since the owner, ang owner pa niyan is yung seller, ano ba yung rule? I think this is what is written here is not consistent with res perit domino because to transfer ownership, kailangan i-deliver mo yan siya, di ba? So therefore, since it is before delivery, the risk of loss here should be borne by the seller. But after delivery, the buyer now bears the risk of loss. Obligations of the vendor. So ano yung obligation ng vendor? Of course, to transfer ownership by delivering the ownership. Deliver the thing and with its accessions and accessories, if any. Kasi di ba, we have this principle in obligations and contracts na kung ano yung binenta mo, kung meron siyang mga fruits or accessories and accessions, kasali yun sila. Unless otherwise stipulated. Warrant against eviction and against hidden defects. To take care of the thing, pending delivery with proper diligence. Kasi nakalagay sa Article 1163 ng obligations na dapat every person obliged to give something should take care of it with the proper diligence of a good father of a family. So, pending delivery, kailangan mag-exercise ka ng ordinary diligence to pay the expenses of the deed of sale unless there is stipulation to the contrary. Now, let's talk about delivery. Ownership as a consequence of certain contracts such as sale shall be transferred to the vendee upon actual or constructive delivery. So, kahit na perfected din yung contract of sale, yung ownership hindi pa natatransfer until delivery. Kasi, di ba, yung sale as a title, it does not transfer ownership. It merely gives you the right to demand the delivery of the thing, which is the object of the contract of sale. So, requisites of delivery, identity, meaning yung ano yung identity ng object, dapat kung ano yung pinag-usapan, yun din ang i-deliver. Integrity, meaning kompleto. Kung ano yung nasa contract of sale, yun din talaga complete i-deliver. And intentional, meaning the seller has the intention to transfer now the ownership of the object. When vendor is not bound to deliver, kapag hindi pa nagbayad ng price si vendee and no period for payment has been fixed, even if a period for payment has been fixed, if the vendee has lost the right to make use of the same. So what are the kinds of delivery? Actual or real? By placing the thing under the control and possession of the buyer. Example, ako ang gitunol ang cellphone na akong gibaligya. So that is actual or real delivery. Legal or constructive delivery, using any sign or acts indicative thereof, like I will sell to you a house, so bigay ko sa iyo yung susi or bigay ko sa iyo yung titulo. That is legal or constructive delivery. Quasi-tradition, delivery of rights, no? Credits or incorporeal property, yung mga hindi nahahawakan ng mga rights, no? Kinds of constructive or legal delivery. We have by legal formalities, no? By execution of a public instrument. Symbolic delivery, like delivery of keys or depository where the movable is kept or stored. Tradition longamano, delivery of a movable by mere consent or agreement, pointing at the thing, no, like sayo na yan, tapos nag-exchange siya kayo ng payment. Ayan. So that is traditio longa mano. Traditio brevi mano, buyer simply continues in possession of the thing but under ownership. Like for example, yung lessee, binili niya yung thing list. So, hindi na pwedeng, hindi na kailangan i-deliver talaga actually and physically ni seller kasi siya naman talaga ang in actual possession ng thing sold, di ba? So that is traditio brevi mano. Traditio constitutum possessorium, iba naman ito. Yung lessor ang in possession ng property pero in another capacity. Like si lessor, binenta niya kay lessee yung property pero yung in possession ngayon si lessor. So, si lessor pa rin yung magiging magpo-possess ng property kaya lang hindi na siya may-ari. In some other capacity na yung may-ari na is the lessee. That is traditio constitutum possessorium. What if yung delivery ng goods is through a carrier? This is also nowadays, di ba? Kasi uso na ngayon yung meron na tayong mga carrier ngayon, di ba? Hindi na talaga yung buyer and seller nagmi-meet, no? At a certain place para mag-deliver ng thing. So what is the general rule here? Delivery to carrier is deemed to be delivery to the buyer. So kapag na-deliver mo na yan sa LBC or sa Food Panda, then that is deemed delivery to the buyer. Exception, where the right of possession or ownership of specific goods sold is reserved. O kung ni-reserve ni seller, kahit na binigay niya sa carrier, kung ni-reserve pa rin niya yung possession or ownership, then hindi siya deemed to be delivery. Place of delivery, saan ba i-deliver? Depende sa agreement, no? Kung ano yung place specified in the agreement, then that will govern. Kasi kontrata, di ba? Where there is no agreement, then usage of trade. Like for example, sa mall. So alangan naman na yung mall mag-deliver sa bahay mo. Labas na lang kung meron talaga silang delivery, no? Pero talagang kung saan yung normal trade nila, so doon talaga yung place of delivery. Kapag walang agreement at walang prevalent usage, then seller's place of business. In any other case, seller's residence. So remember this rule. Unpaid seller. An unpaid seller is one who has not been paid at the whole amount of the price or one who received a negotiable instrument and it has been dishonored, buyer is insolvent or otherwise. So ano yung right mo ngayon? Kasi hindi nagbayad si buyer. Right to lien of goods or the rights to retain them for the price while he is in possession of them. So kung hindi mo pa na-deliver yung goods, i-retain mo lang, no? Lien, that is lien. Right of stoppage in transito, nangyayari ito kapag na-deliver mo na sa carrier. So pwede mong ipastop yung delivery. Right of resale, so ibenta mo na lang sa iba kasi hindi naman niya binayaran. Right to rescind the sale, meaning to say, ika-cancel mo na ngayon yung sale. Double sale. Ano ba itong double sale? Binenta mo sa dalawang tao, okay? Ano ba yung, kailan ba nag-i-exist yung double sale? Kapag merong 2 or more valid contract of sale. Take note dapat valid yung contract of sale. Then, may 2 or more buyers. Then they must pertain exactly to the same object. Same lang yung object na binenta. And they must be bought from the same seller. Same dapat yung seller. So ano yung rule natin sa double sale? Rules of preference. Kapag movables yan, kung sino yung first nag-take ng possession in good faith, kapag sinasabing good faith, hindi niya alam na binenta sa iba. That is good faith. Pero kapag alam niya na binenta sa iba, binili niya pa rin, then that constitutes bad faith. So therefore, kahit na ikaw yung nag-possess first, hindi mapupunta sa'yo yung preference. What about real properties? First, registrant in good faith. So kung ikaw yung unang nakapag-register, then in good faith ka, then ikaw yung magmamayari. Second, first possessor in good faith. So kung wala sa dalawa ninyo nakaparegister, so kung sino yung unang nakapossess. Pero dapat in good faith. Person with oldest title in good faith. Kung ikaw yung may pinakalumang title, then ikaw yung magmamayari. The requirement of the law then is twofold. Acquisition in good faith and registration in good faith. Good faith must concur with the registration. If it would be shown that the buyer was in bad faith, the alleged registration they have made amounted to no registration at all. Kahit nauna ka pa, no? Basta bad faith ka. Conditions. Ano yung conditions? An uncertain event or contingency on the happening. Conditions may be waived or considered as warranties. Effect of non-fulfillment of condition. If the obligation of either party is subjected to any condition and such condition is not fulfilled, such party may refuse to proceed with the contract or proceed the contract, waiving the performance of the condition. If condition is in nature a promise that it should happen, the non-performance of such may be treated without as breach of warranty. Kapag nag-promise ka talaga na mangyayari, di ba? Tapos ngayon hindi nangyari. So, magiging breach of warranty siya. Ano yung warranties? It is a promise that the fact is true. Na sale, it is a statement of fact about the quality or character of the goods sold to induce the sale relied upon by the buyer. Parang sinabi mo ba na maganda to, mag-last to, yung battery niya mag-last ng 24 hours, pero hindi pala. So that is warranty, no promise. Tsaka yun yung naging reason, nirely yun ng buyer, kaya niya binili. Breach or violation of it gives rise to a suit for damages. Warranty is enforceable only against the immediate vendor of the party dispossessed. Kinds of warranties, express and implied. Ano yung express? Kapag sinabi mo, express, di ba? Yung implied naman, hindi na kailangang pag-usapan. Inherent siya, no? Like, ano yung mga implied warranties? Warranty as to seller's title. Like, kung nagbenta ka ng bagay, there is an implied warranty na ikaw yung may-ari, no? That is, that you have the title to that thing, subject of the contract, no? Warranty against hidden defects, na talagang yung product or yung goods na binenta mo, wala siyang defects na hidden, okay? And warranty as to fitness or mercantability. Like, di ba, yung common ito, yung mga equipment, yung mga furniture, or, ay, hindi pala furniture, mga equipment ba, like TV, like refrigerator, di ba, sinasabi lang, may 10-year warranty yan, no? Kapag merong mga factory defect. When implied warranty not applicable, so hindi mag-apply sa mga as is and where is sale. Sale of second-hand articles, no? Wala na yung implied warranty. Sale by virtue of authority in fact or law. So ano itong warranty against eviction? Vendee is deprived of the whole or part of the thing purchased. Ibig sabihin nito, pag nagbenta ka ng lupa, you warrant na hindi mapapaalis yung buyer dyan. Di ba? Yan yung guarantee ng seller. And itong warranty against eviction is an example of an implied warranty. So meaning to say, hindi siya kailangan i-stipulate. No? Hindi kailangan pag-usapan kasi implied siya. What are the elements of warranty against eviction? Vendee has been deprived in whole or in part of the thing purchased. It's either na evict siya from the property, na paalis, or deprived by virtue of final judgment, no? Kinasuhan siya, then napaalis siya. Judgment is based on right prior to the sale or act imputable to the vendor. Like, yung vendor pala, binenta niya pala sa iba. Hindi na pala siya yung may-ari ng thing. Pero, doon sa titulo, siya pa rin yung nakapangalan. So, ngayon, ang nangyayari, dahil sa kagagawa ng vendor, napaalis si vendee. Vendor was summoned in the suit for eviction at the instance of the vendee. There is no waiver on the part of the vendee. Warranty against hidden defects of or encumbrances upon the thing sold. Requisites: defect must be important or serious. Must be hidden. must exist at the time of sale. Vendor must give notice of defect to vendor within reasonable time. Action for rescission or reduction in price must be brought within 6 months from delivery or 40 days in case of animals. No waiver of warranty on the part of the vendee. Dapat hindi siya nag-waive, no? Rules in case of sale of animals. Redhibitory vice or defect. A defect which the seller is bound to warrant in animals, the following special rules shall apply. Defect must be hidden, must be of such nature that expert knowledge is not sufficient to discover it. Veterinarian is liable if he fails to discover or disclose the hidden defect through ignorance or bad faith. Seller liable if animal dies within 3 days after its purchase due to a disease that existed at the time of sale. But, kuan lang, within 40 days lang, from the date of delivery, no, you can file for a redhibitory action. Easement or servitude is an encumbrance imposed upon an immovable for the benefit of another immovable owned by a different person. The very common example of this is road right-of-way, no? So kinds of easement or servitude, apparent easement kapag it is expressly made. Non-apparent kapag walang external indication of its existence. Requisites for vendor's liability for immovable sold with easement must be non-apparent, not indicated in the agreement, must be of such nature that the vendor would not have acquired the immovable had he been aware thereof. Kumbaga, like for example, nagbenta ka ng lupa na yung lupa pala is daanan siya ng mga neighbors kasi walang ibang access road, no, to the barangay road. So ngayon, binenta mo yan, pero yung road kasi parang nagiging apparent yan kasi nakikita mo naman, meron siya external indication. So kapag ganyan, pag merong external indication, tapos binili pa rin ni vendee, kahit na alam niya na merong easement of right-of-way dyan, then hindi magiging liable si vendor. Ang liability lang ni vendor, kapag yung easement, hindi siya apparent, walang external indication, no? Ano bang example nito? Easement of light and view. Kasi alam nyo, yung mga ano kasi, yung mga adjacent properties, kapag nagpatayo ka ng bahay, doon talaga sa boundary, sabi ng batas, kailangan naka-firewall ka dyan kasi bawal ka mag-open ng window kasi meron tayong protection ng privacy ng neighbor. So that is pero apparent pa din yun, di ba? Basta ang tandaan nyo lang, kapag yung easement hindi siya klaro, wala siyang external indication, at hindi siya indicated in the agreement, tapos kung for example, alam ni buyer na merong ganyan na easement, hindi niya bibilhin sana, pero dahil hindi mo sinabi sa kanya, binili niya. So yan, magiging liable si vendor, no? Kay vendee. Now, let's go to obligations of the vendee. Tatlo yung kanyang obligation. Accept delivery, pay the price, bear expenses for the execution and registration of the sale, and putting goods in a deliverable state if such is the stipulation. Following rules to follow. Si vendor, hindi siya required to deliver the things sold until the price is paid, nor the vendee to pay the price before the thing is delivered in the absence of an agreement to the contrary. If stipulated, vendor is bound to accept delivery and to pay the price at the time and place designated. If there is no stipulation as the time and place of payment and delivery, the vendor is bound to pay at the time and place of delivery. In the absence of stipulation as to the place of delivery, it shall be made wherever the thing might be at the perfection of the contract. This is familiar, no? Kasi nasa contract ito. Nasa obligations and contracts. If only the time for delivery has been fixed, the vendor is required to pay even before the thing is delivered to him. Delivery in installments. Buyer is not bound to accept delivery or pay the price thereof by installments. No? Like, for example, bumili ka ng 100 cavans of rice. Tapos ang dineliver sa'yo 50 lang. So, pwedeng hindi mo i-accept. No? Unless na lang, merong stipulation. Kasi, isa sa mga requisite natin sa delivery is the integrity, meaning the completeness of the thing delivered. So si buyer, meron siyang right to examine goods. No, I have a familiar experience dito, no, yung meron kasing online seller na tinanong siya ng mama ko na pwede abrihan ang box. Sabi ng seller, kung saan na-adira sa box, muna na yan lang, ma'am. So, meaning, parang hindi aware si seller, no, na yung buyer has the right to examine the goods. No? So, you can really demand, no, to examine the goods before accepting them. Except na lang kung mayroon sa kayong agreement na hindi na-examine or stipulation that goods shall not be delivered to buyer until he paid the price. Or cash on delivery, yung uso, di ba? Time and place of payment. So, dahil contract ito, time and place stipulated. Time and place of delivery of thing in the absence of stipulation. Suspension of payment. When buyer may suspend payment, if he is disturbed in the possession or ownership of thing bought, or if he has a well-grounded fear that his possession or ownership would be disturbed by a vindicatory action or foreclosure of mortgage. So pwede palang mag-suspend ng payment si buyer kapag disturbed siya sa kanyang ownership or possession. However, the buyer may not suspend payment if nagbigay naman ng security si vendor or kapag nagsabot sila na hindi pwedeng mag-suspend ng payment, or the vendor has caused the disturbance or danger to cease, or the disturbance is a mere act of trespass, or vendee has fully paid the price, no? For obvious reason, nabayaran niya yung entire price, kaya ano pa yung isa-suspend, di ba? Wala na. When vendor may rescind the sale. Pag meron siyang reasonable ground to fear the loss of immovable property and loss of the price. If one or both grounds do not exist, the vendor may choose between fulfillment. Take note here that and. Dapat loss of immovable and loss of the price. Kasi kapag wala daw yung isa dyan or both of them, ito yung remedy. Fulfillment with damages and rescission with damages. Take note here that rescission of real property is not automatic. Ano ba yung rescission? Yung ipa-cancel mo yung contract because you should make a demand first before you can cancel the contract. Maningilsa ka before ka mag-rescind, no? Sale of movables. Rescission of the sale shall take place at the option of the vendor if at a time fixed for the delivery of the thing, the vendee does not accept delivery. Kasi obligation ni vendee, di ba, to accept. So kapag hindi niya in-accept, so the rescind does not pay the price unless a longer period of payment is stipulated. Breach of contract o sale of goods. Ano yung pwedeng action by the seller? Action for payment of price or collection, or for damages, or for rescission. On the part of the buyer, action for specific performance. No? The seller has broken the contract to deliver. Like hindi dineliver ni seller, so pwedeng mag-demand ka, file ka ng action para i-deliver niya. In case of breach of warranty by the seller, accept the goods and ask to reduce or extinguish the price. Accept goods and maintain an action for damages. Refuse to accept the goods and maintain an action for damages. Rescind the contract by the return of goods and recover of price. Now, let's go to extinguishment of sale. So, gaya ng normal na obligation, so ito yan, same lang, di ba? Payment or performance, pag binayaran or pag dineliver. Prescription, loss of the thing due, annulment, novation, condonation or remission, confusion or merger, compensation, rescission, or the happening of a resolutory condition. Or ito by the various causes of extinguishment in Title 6, like cancellation of sale of personal property in installments, resale, rescission of the sale by unpaid seller, rescission by the buyer in case of partial eviction, rescission by buyer in case of breach of warranty against hidden defect, or rescission by buyer in case of animals with redhibitory defects, or by redemption. May tatlong klase ng redemption. No? We have conventional redemption, legal redemption, and ano yung isa? Tatlo ba? Dalawa lang pala. Okay. conventional redemption and legal redemption. Ano yung conventional redemption? Kapag agreed to by the parties na merong redemption. No? So, period of redemption, kapag walang agreement kung kailan dapat mag-redeem, under the law, 4 years from the date of contract. Kapag merong agreement, kailangan hindi mag-exceed ng 10 years. Any excess daw will be null and void. Civil action between the parties 30 days after final judgment. Okay. So again, dalawa yung klaseng redemption, conventional and legal redemption. So when you say conventional, kapag pinag-usapan, merong agreement no, for redemption. Again, kapag walang agreement as to the period, 4 years. Pag may agreement, dapat hindi ma-exceed ng 10 years. Otherwise, yung excess null and void. Civil action between the parties 30 days after final judgment was made, provided that the contract was a true sale with a right to repurchase. Effect of failure to exercise, ownership shall be consolidated in the vendee. In case of real property, a judicial order is required for the purpose of recording the consolidation in the registry of property after the vendor has been duly heard. Equitable mortgage, one which lacks the proper formalities of a mortgage but shows the intention of the parties to make the property subject of the contract as security for a debt. Yung bang nag-execute kayo ng deed of sale pero ang totoo, utang pala yun siya. No? Parang ginawa mong automatic no, na in case hindi siya makabayad, i-transfer mo agad yung ownership ng property. Sabi ng batas, that is prohibited. Hindi pwede yan. So kailan ba nagiging equitable mortgage? Ano yung mga indication that a contract is an equitable mortgage? So nandito sa ating slides, number 1, unusually inadequate purchase price. Like yung value ng property 10 million pero yung purchase price mo 1 million lang. So parang hindi talaga siya sale, parang ano lang siya, security. Vendor remains in possession as lessee or otherwise. Like kung sale pa yan, dapat dineliver mo na sana. Pero bakit ikaw yung in possession pa rin? So meaning to say, there is an existence of an equitable mortgage. Extension for period of right to repurchase. Yung lagi lang kayo nag-extend, nag-extend. So parang walang intention to sell, di ba? Purchases retains for himself as part of the purchase price. Vendor binds himself to pay the taxes of the thing sold. Kasi kapag contract of sale yan, yung vendor na sana magbabayad ng taxes. Pero bakit yung vendor? So meaning to say, may indication siya na hindi talaga yan sale, but isang equitable mortgage. When the real intention of the parties is to secure the payment of the obligation. Like, gumawa lang kayo ng contract of sale for the purpose of securing the loan obligation. Hindi talaga for the purpose of transferring ownership over the property. So kapag equitable mortgage yan, bawal yan. So therefore, hindi mo pwedeng i-transfer yung ownership ng property. No? Kasi isa siyang equitable mortgage. Legal redemption. The right to be subrogated upon the same terms and conditions stipulated in the contract in the place of one who acquires a thing by purchase, datation in payment, or any other transaction whereby ownership is transferred by onerous title. So it can be exercised within 30 days from notice in writing by the vendor. Note that written notice under this provision is mandatory for the right of redemption to commence. So who can redeem? Co-owners. Like for example, in one property, may 5 co-owner. Yung isa, binenta niya yung kanyang share. So ngayon, yung ibang co-owner, pwede niyang i-redeem from the buyer. Kasi co-owner sila. Adjacent owners of rural lands, like magkatabi yung lupa ninyo. Yung silingan mo, binenta niya yung lupa niya. So pwede mong i-redeem yon sa buyer. Kasi sabi ng batas, you can. And adjacent owner of urban lands. So same with rural lands. Pwede mong i-redeem kapag yung neighbor mo, binenta niya to third person yung lupa niya. So we also have this principle of preemption. Yung before mabenta, merong right of preemption yung person, no? So anong kaibahan ng preemption at saka redemption? Yung preemption, nag-arise yan before the sale. Yung redemption arises after sale. In preemption, no rescission because no sale as yet exists. In redemption, there can be rescission of the original sale. The action is directed against the prospective buyer, while in redemption, the action is directed against the buyer. in preemption may attach to the seller's duty to deliver or some other circumstances, but in redemption, always relate to the subject matter or the seller's obligation. The period shall be exercised within 30 days from the notice in writing by the prospective vendor or by the vendor in case of preemption. So that ends our review for the law on sales. Thank you very much for listening.